Hello and welcome to the Land and Climate Podcast. In this episode, I spoke to Eunjung Lee, Senior Policy Advisor at energy and climate think tank E3G. Eunjung is an expert in international investment treaties and climate, and I wanted to ask her about her research into international investment treaties and E3G's claim that many of them were potentially damaging for countries trying to decarbonise their energy systems.
Some of the Western European countries are being very selfish and they care about their potential risk to this arbitration mechanism, but they're still posing other countries, other developing countries that need to transition away from fossil fuels by keeping this mechanism and trying to protect their own investors who are investing in fossil fuels in other parts of the world.
I began by asking her to explain the history of investment treaties and what ISDS was.
Investor-state dispute settlement is called ISDS. ISDS provisions are main features of bilateral investment treaties and some investment chapters of free trade agreements, which are around 2,500 in the world in force currently. So these provisions and investment treaty started to appear in the post-colonial period as there were potential challenges of newly independent countries nationalizing or redistributing assets owned by foreign investors. So it was a measure aimed at safeguarding foreign investors' interest from new emerging governments measure. And initially it was to protect investors from arbitrary state conduct, so something like seizing properties and nationalizing without proper compensation. And as time went, it became to protect foreign investors' interest from even legitimate public policy measures, such as public health measures or environmental measures. And that's why it has become more controversial recently in the climate crisis, because one of the most frequent users of the system is the fossil fuel industry.
And so primarily it was led by companies at the time, or was it governments that were influenced by companies that were basically saying we need to protect our investment interests, and it kind of developed after that?
I think it's both, because it's in the interest of home country, of investors, governments, to protect their investors abroad. So it was first investment treaty with ISDS provisions appeared in 1960s, and then this started to pick up in 1970s and 80s, and in the 1990s with free trade and neoliberalism, this became very popular, and the number of treaties with ISDS provision increased very rapidly, and it became something very easily deliverable at like high-level summits and meetings. So government started to sign multiple treaties without giving second thought. And in 2000 and 2010, we see a lot of claims coming on. And then with the public measures and climate action, it has become more controversial.
And so you put a report out last year which suggested that 2 gigatons of potential annual greenhouse gas emissions were protected via investment treaties. So that's 5% roughly of annual global emissions. Can you explain what these impacts are now? And I suppose listeners will want to also know what these treaties are. I know that you've spoken of the Energy Charter Treaty, and there are others. So if you could take us through some of those things.
These ISDS provisions allow foreign investors to challenge government measures if they see government measure undermines business interests. And what foreign investors can then do is bring these claims to international private arbitration, which is not a permanent court, but private ad hoc tribunal of 3 arbitrators. And because of that, there is no precedent, and rulings can be very inconsistent. And then the arbitrators have a lot of discretion in terms of like how they interpret certain provisions in treaties. And a lot of the arbitrators, they're more pro-business. They come from the more business background rather than they're equipped with like environmental law.
Are those arbitrators sometimes even chosen by or influence the choosing of those arbitrators? Who's that determined by?
So 3 arbitrators, and among the 3 arbitrators, one is chosen by the respondent state and another is chosen by the claimant, and the third one is agreed by the both parties. So in the selection process itself is okay, but these arbitrators can sometimes become legal counsel for other cases. So there is an issue of like double hatting. They're sometimes defending this interest and then in another case defending different interests. So about the system itself, who can sue whom is a big problem we can see because it's only foreign investors who can bring these claims against government. There is no the other way litigation possible. And then foreign investors can also bypass national court and just go straight to the private arbitration panel, which doesn't sound great. And how those arbitrators decide a ruling in the claims, instead of looking at how much investment investor already made, what they tend to look at these days is looking at lost future profits, which is very speculative. There are cases where the final award was multiple times more than what the investor has invested. So this is skewed towards giving very excessive compensation to the investor side. And if you think it from the climate perspective and the fossil fuel industry, this means that government who is trying to take more ambitious climate measures, such as phasing out oil and gas assets, are required to compensate fossil fuel industry with a lot of even billions of dollars of money.
And it would be good to go into some of these examples for our listeners to understand what kind of some of the specific cases that have taken place already. Because I think just from reading your report that people might be surprised by the sums of money involved in some of these settlements.
Yeah, there are a few very important cases. One I can talk of is a UK company called Rockhopper against the Italian government. So Italian government decided not to allow offshore oil and gas exploration. And therefore, they rejected this UK company Rockhopper's application of oil drilling license. And as a result, Rockhopper brought this case to arbitration panel under the Energy Charter Treaty. And the panel awarded in favor of the investor, Rockhopper, and ordered Italian government to pay this Rockhopper company around $180 million. And it's estimated what this company actually invested was around $30 million. And they didn't even started to produce oil. So it's for something that never really happened. The government was asked to pay nearly $200 million. And what's more interesting in this case is this fossil fuel exploration company then used this award money to develop another oil and gas fields. This mechanism is promoting fossil fuel interest and promoting more production of fossil fuel assets.
It's not just climate, is it? I suppose if we're talking about some of the interests, there's mining as well. So there are kind of environmental issues on top of the climate ones. So there was this Pakistan mining case.
Pakistan mining case is interesting primarily because of the compensation ordered by the arbitration tribunal. So it was a few years ago. It was between Pakistani government and the Australian investor, and Pakistan government rejected this investor's application of copper mine license.
Right, so it's an Australian mining company.
Yeah, an Australian mining company. And the arbitration decided in favor of the Australian mining company, but the amount of compensation that the arbitration panel ordered and asked Pakistani government to pay the Australian investor was nearly $6 billion. And in the same year, Pakistani government secured a loan from the International Monetary Fund, which was similar amount. So for developing countries, especially a small-sized economy, the impact of one claim means huge impact on their fiscal space.
Right, and I mean, $6 billion is probably big for any government.
Another case, which is even where we talk about even bigger amount of money. So there is Australian investor called Cliff Palmer, and he's set up his company, mining company in Singapore. He himself is an Australian investor, but he set up company in Singapore, and through his company in Singapore, he has so far brought 4 claims against Australia, and the amount of compensation he's asking the Australian government in those 4 claims in total is around 420 billion Australian dollar, and it is equivalent to 260 billion US dollars. All 4 cases are in the mining sector, but 2 cases are against the refusal of coal mining license in Queensland. And this refusal was based on environmental grounds and human rights reason. And this included the impact on greenhouse gas emissions. So the local court decided that giving this company a coal mining license would undermine their environment, taking into account the impact of greenhouse gas emissions, and the government followed that ruling and decided not to give the mining license to the Singaporean company held by Australian investor. And as a result, he is claiming around 100 billion Australian dollars.
And do we know what stage this case is at now?
I understand these are all pending. So we don't know where this will go. But even just government responding to a case, the proceeding itself is very costly. So even if the government wins a claim, the average says is around $5 million that the respondent government needs to spend to deal with a case.
I mean, this is big business for international investment arbitration and no doubt legal firms, etc. as well. We've picked a few examples of quite big or interesting cases with a lot of money involved or impacts on climate outcomes, etc. But it'd be interesting to get an idea of, is this happening all the time?
What's also striking about this particular arbitration mechanism is that there is no obligation for the parties to disclose all the information about a case. So we don't even know how many cases are out there. And in terms of publicly available cases, I think it's like hundreds of cases out there, but there can easily be many more than that. And we don't even know the scale of the problem.
It sounds like this isn't just an issue for developing countries, and it's also an issue for so-called developed countries.
Yeah, that's, I guess, where the Energy Charter Treaty is interesting. So Energy Charter Treaty is multilateral investment agreement, which came into life in the wake of post-Cold War era. So the main aim was to protect Western investors in the countries where used to be the Soviet Union in the energy sector. And the treaty has exactly the same dispute settlement mechanism, ISDS. So the Energy Charter Treaty is the most invoked treaty in the world historically, but our research also shows that looking ahead, this is the most dangerous treaty to the energy transition because of the amount of fossil fuel assets protected under this particular treaty. And its membership is more than 40 countries now. It used to be more than 50 countries. But what happened was that Western European countries realized this treaty could be a threat to their energy transition. So decided to negotiate with other signatories to see if they can modernize the treaty or upgrade the treaty to make it work better for the climate. However, after years of negotiation, they decided the negotiation outcome was not good enough to meet the net zero goals. So more than 10 European countries, including countries like the UK, Germany, France, decided to leave this treaty. And the European Union as well announced to leave this treaty last year. This happened because under these treaties, Western European countries are exposed to potential claims from other developed nations as well under this treaty. So they saw this treaty as a threat to their own transition. So they decide to leave this treaty. However, as I said in the beginning, there are more than 2,500 bilateral investment treaties in the world which do exactly the same thing. But what's shocking is the same European countries that decide to leave these Energy Charter treaties are not doing anything about other bilateral treaties they've signed up for, which are posing risks to the energy transition of other countries. So here what we see is some of the Western European countries are being very selfish and they care about their potential risk to this arbitration mechanism, but they're still posing other countries, other developing countries that need to transition away from fossil fuels by keeping this mechanism and trying to protect their own investors who are investing in fossil fuels in other parts of the world.
So there are a huge amount of constraints then for decarbonisation measures and huge threats, I suppose, for particularly the developing countries, which may not have as developed legal experience to defend certain cases, I suppose, as well. I did catch in your report, you mentioned, one of the countries you mentioned is Colombia. As Colombia seems to be attempting relatively radical measures to decarbonise. I think you mentioned potential risks for them.
Yes. So in our report, what we try to do is to look at global fossil fuel assets and to work out how many of them are protected by ISDS mechanism. And our report says around 12% are protected by ISDS. But if you think about how the percentage of the global fossil fuel assets protected by ISDS of the assets that are owned by foreign investors, the percentage is around more than 60%, which I think is pretty high. And in our report, we try to see which countries are most exposed to potential ISDS claims associated with fossil fuel assets. And at the same time, we try to see which countries are posing most risk to the global energy transition by allowing their own investors to bring claims against government measures in the countries they own fossil fuel assets. And Colombia is one of the most exposed country to potential ISDS risk. And what's interesting is Colombia at the same time is trying to transition away from fossil fuels, and it's a friend of a global alliance trying to phase out oil and gas called Beyond Oil and Gas Alliance. But our research also has found that the other members of Beyond Oil and Gas Alliance themselves are also posing risk to the energy transition of Colombia as well. So even within the same alliance, with countries with the same goal of phasing out oil and gas, we can see some of the members could be potentially posing risk to the other members phasing out from oil and gas.
And that's because of the investment treaties which exist.
Yeah. So looking at it from the investment treaties and looking at fossil fuel assets in Colombia that are protected by foreign investors, we can see quite a lot of those assets are protected by investors of the countries who are also members of this Beyond Oil and Gas Alliance.
It's probably worth going on to what you see as some of the solutions and what the possible ways out of this. How can we get beyond? Is it a question of just countries leaving these treaties, as some did with the Energy Charter Treaty?
I think ideally, withdrawing from this current mechanism would be the fundamental solution to the system. For example, terminating or withdrawing from Energy Charter Treaty or any other investment treaties which have ISDS provisions. However, these bilateral treaties are not just about energy sector, so we also understand the complexity of solving the issue. We see the starting point is really to recognize ISDS as a problem in dealing with the climate crisis, and countries really need to evaluate whether the benefits of these treaties are more than the cost that they might face. And we don't think this is being done at the current stage. And particularly in the climate crisis, that's what needs to be done in the first place. And then they can review their current approach. So they can think about, easy thing will be not signing more treaties in the future. So don't do it anymore from now on. But they can also think about either leaving the existing treaties or substantially reform existing treaties. Although what we need to think about is it worth making a lot of effort to make some changes to these treaties despite all the resources that need to go into this? Is it better to leave the treaty? That's another thing that they need to think about. But because there are so many treaties in the world and it's very complex system, so you need another partner to agree to you and reform things together. So what we think is important is plurilateral approach or multilateral approach. So we think it will be important for like-minded countries who see ISDS as a problem in the climate context or more broadly, and join their forces and trying to solve this problem together.
How realistic do you think that prospect is? I mean, you've worked in government. Is the mood changing on how people look at these investment treaties and the dispute settlement?
There is a country like Colombia who recently said they will renegotiate their existing treaties and rethink about ISDS provision. There is certainly some countries who are thinking about getting out of the treaty. However, the impact of these treaties on climate is still not fully integrated in wider climate discussion, despite the significant effect it can have on the phasing out fossil fuels, or like we saw from the Pakistani case, how much impact one case can have on physical space and therefore affecting finance that can be used to deal with climate action. So it will be important for this topic to be more integrated in wider climate discussion. And for example, venues like G20 or COP, although it won't be a space for technocrats to discuss how to reform these treaties, but the need of addressing ISDS mechanism in the context of climate being discussed in these multilateral venues would certainly give a political momentum and opening that can lead to more accelerated discussions of investment treaty reform globally.
I'm guessing there are other disputes which have been undertaken by companies, which are about other issues, which have other potentially detrimental impacts for government actions.
Well, of course, we're paying more attention to climate-related issues because we think it is particularly important in current stage, but the impact of ISDS isn't limited to climate measures or wider environment measures. One example is Australia many years ago tried to adopt new packaging around tobacco, and then the foreign investor brought a case against Australia for taking such measures because that would reduce the sales of tobacco.
I think you wanted to talk about the UK and the ISDS, or maybe the Energy Charter Treaty in relation to the UK.
So in our report, we've identified UK protecting more emissions than any other country associated with fossil fuel assets protected by ISDS. And if we look at G7 in total, these emissions protected by companies based in G7 through ISDS amount to 50%. And UK is interesting because it is one of those countries who are leading global efforts to accelerate the global energy transition, and in terms of mobilizing climate finance to enable the transition of developing countries as well. But despite all the efforts, on another hand, UK is potentially making other countries getting out of fossil fuels harder by keeping this ISDS mechanism. Our analysis clearly shows how investment protection given to fossil fuel assets through ISDS is misaligned with other international efforts to phase out fossil fuels and achieve climate goals. For example, UK has been leading global initiative and public finance support of fossil fuels, but at the same time, through this ISDS mechanism, UK is de facto protecting their fossil fuel investors' interests abroad. So they have made a commitment not to support fossil fuel investors abroad through different mechanisms, but using ISDS, they are giving backdoor to the protection of fossil fuel interest.
Thanks very much to Eunjung for her time. As usual, there's further reading on the subject in our podcast blurb. Thanks also to Vasco Kostovsky for audio engineering the show. Bertie will be back in 2 weeks' time for our next episode, and do also check out our website for new articles, and you can also now find us on Blue Sky. Until soon, and thanks for listening.